So, if I can introduce myself again, I'm Karen Hamilton and I'm a partner in the planning team here at Brodies. And I'm delighted to be joined this afternoon by two fellow partners. So, first of all, we have Neil Collar. Neil is also a partner in the planning team and very much a regular on these sessions. I don't feel that Neil really needs much of an introduction to you. I'm sure Neil will be known to most of you. But also joining us this afternoon is Sarah-Jane McArthur. I think I'm right in saying, SJ, that you are a first-time guest on Planning Live. I'm sure you must be very excited about that. SJ is a projects lawyer. She's a partner in our energy and infrastructure team. She focuses on renewables and low carbon projects and has significant experience in project delivery and advising clients on the structuring of projects. She is also a specialist in all matters concerning grid, which really takes us on to the topic of today's discussion. So today we're going to be discussing a matter which should be of interest to anyone who's interested in renewables and energy projects, and that is the question of the grid. So slightly outside of our usual pure planning chat, but I think you'll agree it's an essential component of project delivery. So we're going to look at what's been changing under grid reform and how that impacts on planning requirements, if at all, and what you need to know about all of those things. So if I can perhaps kick off, SJ, with a question to you. So for those who may not be so familiar with the electricity sector in the UK, can you perhaps give us a sort of brief overview of how the sector is organised in terms of the activities that are regulated and who the main players are within the sector and their roles at a sort of high level?
Thanks, Karen, and delighted to be invited to join you at Planning Live today. So yes, I think that's a good place to start because like many specialist areas, we can be very guilty of acronym salad. And so I think it is worth explaining some terminology at the start. So the electricity sector activities are split into generation, so making the electricity, transmission and distribution, moving it around, and supply, getting it to the end customer. And that's artificially separated for the purposes of regulation. Grid, which we're going to talk about today, involves the distribution and transmission parts, i.e. the cables that transport the generation to the supply. Distribution is the lower voltage sections of the grid. I like to think of it like the B roads and C roads. In Scotland, there are two distribution network operators who own and operate those lower voltage networks. That's Scottish Hydroelectric Power Distribution, and you'll hear them referred to as SHEPD in the north, and Scottish Power Distribution in the south. And then there are 6 others in England and Wales. Transmission is the higher voltage section of the grid, so think of that like the motorways. And in Scotland, those transmission networks are owned by similar Scottish Hydroelectric Transmission in the north and Scottish Power Transmission in the south. And in England and Wales are all owned by National Grid Transmission. Confusingly, you'll hear SSE and SP, Scottish Power, Scottish Southern Energy, referred to as SSEN and SPEN, but that's just a group trade name. Basically, it's their networks businesses, and you have the distribution entities and the transmission entities. Ownership and operation of the transmission system is separate. So the new kid on the block there, I guess, is NESO, who is the National Energy System Operator. There has always been a separate operator of the transmission system, but there's been some regulatory changes so that we now have NESO sitting there. It is responsible for operating the transmission system and for ensuring that supply and demand on the grid is balanced to keep the frequency of the grid within certain parameters. Then we have Ofgem, who is the regulator covering all these segments of the electricity system, including licensing of operators and enforcement. And finally, I think the other key person is DESNZ, which is the Department of Energy within UK government, and they're the department responsible for energy across the UK.
Well,
SJ, maybe just before we go on, and you can tell we didn't script this bit, but that's what's good about it. We can have
no
a chat.
unscripted questions.
I thought it might just be a useful point to pause um, and talk about uh, when there's a planning application for a renewables project, most of the time it needs EIA. And one of the issues that always pops up around EIA is, but you haven't included the grid connection. And without getting into sort of legal issues and things around it, recapping back on what you said, the very practical issue is the generating asset, which is the thing that the consent application is for, is uh, being proposed by an entirely different entity from the entity that would be responsible for doing the grid connection.
For the most part, that is correct.
That's a
So,
good lawyer answer.
um, and with we're very much in danger of going down a rabbit hole, but just briefly, the standard approach for many renewables projects is to have the distribution network owner or the transmission owner bring the cable to your site. So you have your generating asset, you have a substation on the site, and that substation on the site is your point of connection, and everything beyond that, all the cables beyond that, are the responsibility of the network company. However, to increase competition and reduce costs, some of that cabling work is now referred to as contestable work. So you'll hear non-contestable works and contestable works. So the non-contestable works are the works which the distribution company or the transmission company must carry out. But those other parts of the cabling works are now contestable, and so you can have private companies carrying those works out. And in that situation, the generator is actually responsible for the delivery of those cables. So probably doesn't help because that probably makes things worse from a planning perspective, but it's not always just the responsibility of the network business.
I think we're already demonstrating the sort of complexity of this area. I feel I've learned a few things already. And what we need to do is, following this session, issue a glossary of all these terms that we've already hit on the head. But thanks, that's a really good introduction just to get us into it. So I suppose getting planning permission is always one of the key challenges that we have in mind for renewables projects. But increasingly, what we're hearing is that getting a grid connection is a bigger issue. So can you perhaps set the scene for us on the grid challenge? Sarah-Jane, why is it that it's becoming so difficult?
Fundamentally, our electricity system has changed. So in the old days, we had a system that was designed to transport huge volumes of electricity from large centralized power stations, coal or gas, out on progressively smaller cables and wires to the homes and businesses where it was used. But now our generation is spread across the country, often in areas where it can't really be used. So offshore wind, for example, it can't really be used offshore, although with the exception of the offshore wind that's going to power perhaps some oil and gas infrastructure. But even if you think about wind farms in the far north of Scotland, the demand there is not particularly high. And as we decarbonise our whole economy, we're also increasingly electrifying heat and transport. And both of those factors mean that we need more and more grids. So for a while now, there has been significantly more connection requests than there is available capacity on the grid. And grid has always been playing catch up to the demand for it, so that we're in a position now where the grid queue has around 4 times the generating capacity that we might need by 2050. This very lengthy queue means that projects seeking a grid connection offer now can face waits of more than 10 years to get connected, and the cost of that work required is substantial. And so NESO are taking steps to manage and reduce that grid queue to try and facilitate getting quicker grid connections.
And could you perhaps give us a sense of, if I mention the word or the phrase zombie projects, which is something that people talk about in this area, I take it that's really what's driving the need to look at the management of the queue in terms of who has got those connections, and are they perhaps the right people to be having those connections at the right times?
Yeah. Exactly. So in terms of queue management, which is the first, if you like, tool in the toolbox that NISO introduced to address the grid queue, and that's been in effect now since November 2023. And it was intended to try to prevent these so-called zombie projects blocking capacity. So what queue management does is it introduces a set of fixed milestones into every single grid connection offer. They're the same for every project. And essentially what those milestones do is require each project to demonstrate progress against the milestones, so showing that their projects are still moving forward or risk losing the grid connection offer. The milestones are split into some early stage ones and then ones that relate more to construction. So we have the first three, M1 to M3. They're the early stage milestones, and M1 is submitting a planning explanation. M1 is submitting a planning application. M2 is securing that planning permission, and M3 is about securing land rights. There are then dates by which those milestones must be satisfied, and although they are specific to each generator, they are calculated using a published methodology and calculated backwards from your planned connection date. So essentially, as you might expect, the further away your grid date is, then the longer you have to complete those milestones. There's a complicated table to work it out. It's not particularly complicated, but I'm not going to go into it now. Just to give you an example, if you receive a grid offer today with a connection date that's 5 years in the future, then you'll need to complete M1, submit your planning application within the next 12 months. It's 4 years before your expected grid date. And then you'll need to complete M2, which is getting your planning permission within a further 18 months. So 2.5 years before your grid date. If those milestones are not hit, then subject to a 60-day remedial period, NISO can terminate your grid connection offer. So essentially a delay to planning can now risk losing your gig connection, which significantly increases development risk from where we used to be, and in some respects might change the approach to development programs, because developers have usually always secured grids, secured their land rights before they spend significant money on planning. But now that planning process is on a fixed timetable in the grid documents, you can see how grid, land and early planning work are going to have to be combined in a slightly more efficient way in order to achieve the milestones in time.
And when you're mentioning there the risk of delay to planning and the risk of losing your place in the queue, what if that delay is something which is out with the developer's control? Dare I say, a developer that may be faced with a planning authority that perhaps has been slow in processing the application, or as we know is common, inputs from statutory consultees, holding things up, or any number of reasons that may be down to third parties. Does that make a difference?
There are some limited exceptions, but the general principle is that you need to achieve the milestone, and the evidence for that would be submitting and then receiving the planning permission. I suppose that even though through no fault of your own, the idea is that projects will keep moving, so that if projects are ready, they're the ones that get connected and they move forward.
Okay, and so does all of this place a sort of proactive requirement on developers to be reporting at these for these milestones?
Yes, there's an obligation essentially to report to the grid company that you have satisfied the milestone, and there's a flow chart with the evidence that you require to submit in order to have your milestone ticked. And essentially, they will send the grid companies will send you a reminder. I think there's a 60-day and a 30-day reminder. So they'll have a little chart that says remember you're due to submit your milestone in the next 30 days. But yes, proactively, the developers are going to have to remember that they need to comply with these milestones and gather together the evidence and get it submitted on time.
Okay, and would I be right? I know we're talking about planning permission, perhaps loosely, but presumably this is applying to projects of all scales. So we're talking about Section 36s as well as planning permissions at the sort of 50 megawatt and below.
Yes. If I recall I don't have the document sitting in front of me, but off the top of my head, I think the actual milestone says planning, permission, and all statutory consents, which our understanding of that is that it means the other consents that are akin to planning, permission. And in fact, when you look at the evidence that's required, it could be submitting your Section 36 or a DCO or indeed demonstrating that you do not need planning for your project.
Okay, well, that would make sense. So then, Neil, if I can come to you now, then on the subject just of those consents, I mean, what is the relevance of grid when it comes to planning applications, if any? Is that something, is the fact of a grid offer something that would be taken into account when a planning application for a renewable project is being determined?
Yeah, this is one of the reasons why we thought this would be a good topic to discuss, because within planning, there's a habit, whether it's on the applicant side or an objector side, of throwing in information. And planning, obviously, we talk about planning considerations, material considerations, because that's what flows through from the statute. But we know in practice that has a very wide definition. So it does make it quite hard to pin these sorts of things down. And to maybe point the finger at an applicant first, it is something that if you're applying for permission and you have a grid connection date, quite often that's something that would be mentioned. And you can understand why, because it gives a positivity in terms of deliverability. If you give us the consent, we will contribute to renewable energy targets because we have a grid connection. It's a positive, very constructive message. And in reverse, an objector might say, as far as we can see, this project does not have a grid connection date, or because of known deficiencies in the transmission infrastructure, it probably wouldn't get connected for 10 years, or. The answer to your question, you'll be glad I'm coming to an answer. If you look at MPF 4 within policy 11, the energy one, what Scottish governments say is grid capacity should not constrain renewable energy development. So it's quite clear that while it might suit an applicant to mention it, and while it might suit an objector to mention it, the decision maker is looking at the merits of the project, and that doesn't include whether or not it has a grid connection. Just picking up on the other elements that SJ was mentioning in terms of the milestones, and again, this was another reason why we thought this would be a good topic to discuss. One of the things that is always difficult for people involved in the planning system is projecting peaks and troughs in demand, as it were. Why is the planning officer too busy to deal with my application? What are the pressures on the system? And it's quite clear from what SJ is talking about that this new approach is going to increase that demand. There may well be some artificial peaks and troughs created. But, for instance, from what I was scribbling down, M1, the deadline for submitting a planning application, if you need an EIA report, you've got to have the relevant consultants. So it may well be that this system will increase the demand on EIA consultants. So there's a point there for people looking towards preparing applications to say, you should probably get your professional team appointed earlier than you do at the moment, because otherwise people's diaries might already be full and you might struggle to reach that milestone. And we all know the difficulties, the awkwardness is about submitting an application that doesn't necessarily have key information. And certainly you can't submit it without the EIAR if you require an EIAR. So that's the M1 deadline. The M2 deadline, and there was some discussion of this already in terms of the getting of the planning permission. We get asked all the time, and in fact, most of the time we get asked the question, it is prefaced by, I know this is really how long is a piece of string, but how quickly will I get my consent? And it is very hard to predict. And in part, part of the reason for that is certainly within planning authorities, there are no agreed practices in terms of what gets prioritised and what doesn't. And there's no sense of a queue system. You know, it's not the application that was submitted first gets decided ahead of an application that was submitted later. So to the extent that there's a queue, depending on when you were submitted, things can jump the queue. And going back to what you said, Karen, it can be as simple as things like a statutory consultee could respond more slowly to one application than another. So if the statutory consultee response is back, then you could understand why the planning officer would keep going on that application. And while they're focused on that application, the other one, which was maybe submitted earlier, gets delayed as a result. And there's no sort of agreement or policy that renewables applications will get prioritised. So all the other applications, and that will depend on the pressures within the particular council that you're dealing with. It's a slightly different scenario, obviously, within Energy Consents Unit, who are doing the Electricity Act application. So that's the Section 36 is for generation, Section 37s for overhead transmission. They are just focused on its energy applications, but the reality is most of them these days are renewables. So there's an inherent prioritisation there before you start. But at the moment, because achieving the 2030 target relies on transmission being upgraded, Energy Consents Unit do have a published policy about how, particularly this year, because this year is key for transmission consenting, they're going to try and prioritise transmission applications and get those through to consent. So in thinking about your M1s and your M2s, there's a lot for applicants, their professional team to take on board. And it really does ramp up. And that goes back to the question you asked, SJ, which, you know, to paraphrase, how serious a deadline are these? And the response was really, yeah.
Oh, Neil, I think you've perhaps. Oh, I think you maybe hit mute for a minute there. Are you back with us?
Oh.
No, Neil, I think you're still on mute. But SJ, perhaps you can pick up on a question that has just come in from one of the listeners, which is to ask, in terms of those timelines for the M2 securing your consent, is there an allowance built in for PLI? So that would really be thinking more about Section 36 applications. As we know, those can end up at an inquiry, particularly if the local planning authority does object. So obviously that will very much lengthen the process.
There, in the list of exceptions, appeals, so planning appeals and third-party challenges not defined, would enable you to ask for an extension. What I'm not sure because this is an interesting question to now go and have a look at, is whether a public local inquiry would fit in to that concept, or whether that, because it's pre-consent, it's not really a challenge. That's an interesting thing we should definitely go and have a look at.
So we can follow up on that now. Before I move on to my next question, I'm just going to test if Neil is able to say something to us. We'll see if we're hearing you, Neil. You want to say hello?
Can you hear me now?
Yes.
I can certainly hear you. That's good. Neil
Good.
is back. So, but actually, I've got another question for you, SJ, and it really, focusing in on the changes in the system that you've been talking about. So, developers very much being focused on connection reform at the moment. So, can you explain just a bit more to us about that process?
Sure. Yes, anyone in the renewable sector at the moment, this is all you'll be hearing about: connection reform. And so connection reform is really about recognising that queue management is not suddenly going to solve the grid capacity problem, because it's going to take time for projects to miss milestones and be removed from the queue. And in addition, we've talked about those so-called zombie projects that may be blocking more progressed projects from connecting, and how do you get them out and allow the other projects to progress? And this is particularly an issue for the government's Clean Power 2030 mission that Neil was just mentioning, where they need the right projects to get connected by 2030 to achieve that goal. So connection reform is essentially about transitioning our whole grid's queue from what was a first come, first served queue to a first ready and needed queue. And this is going to involve a massive one-off reordering process, which will very shortly be underway this summer by NESO and the distribution network operators. Essentially, every generator will need to evidence that they satisfy certain readiness criteria and strategic alignment criteria, and they'll need to evidence that in order to retain their place in the queue. The readiness criteria is fundamentally linked to securing the necessary land rights for the project. So generators will need to have an option to lease, or a lease, or they'll need to own the land, and they have to demonstrate that that's in place. The strategic alignment criteria is about demonstrating the project's alignment to the Clean Power 2030 mission. And the way that this will be assessed at a really broad level is by considering NESO's projected generation mix scenarios, like their view of how Clean Power 2030 could be delivered, versus how many of those types of projects are already installed. So, for example, how much onshore wind do we need in 2030 versus how much onshore winds we currently have? And essentially, it's all about connecting the right type of projects in the right place. The one thing to bear in mind, though, is that some projects will qualify for strategic alignment through achieving certain protected status. So those projects which are due to connect by the end of next year and have secured their planning permission and are able to demonstrate that they've achieved financial close or secured a CFD or somewhere, in a sense, they're really, really far progressed. They will maintain their place in the queue. There are other different levels of protection afforded to projects which have also reached a certain stage of progression. And again, in this respect, planning permission is important, because if you can evidence that you have secured planning permission by the time of the great reordering, and that planning permission was applied for before December 2024, then you will have a degree of protection. There are some additional criteria, but again, it's quite a long slide of criteria, so I'm giving a flavour. But it's obviously the case now that even just looking at how connection reform is going to be done, that there's much more interdependency between securing planning as a way to demonstrate project progress and securing and keeping your grids than there ever has been before. I think it's also just worth noting that given the capacity of projects in the current queue versus the capacity of projects needed, it is very likely that not all projects will maintain a place in the queue as part of connection reform. some types of projects are particularly oversubscribed. So battery, solar to some extent, where by comparison, wind, both on and offshore, are not particularly oversubscribed, and it's more likely that we'll see more wind projects securing a place in the queue than certain other technologies. I think that's probably enough in connection reform for now.
No, it sounds to be a very painful and significant process. Obviously, we are seeing it. Obviously, Neil and I work with you closely, SJ, as well as on new projects, as well as clients who may be perhaps investing in projects that to date having been brought forward by third parties. And when we're involved in the due diligence project process at the moment, the matters that you've just been discussing are absolutely to the fore in terms of allowing a purchaser to be comfortable about what they're getting into. I know that's a big load of your workload at the moment, looking at those sorts of questions.
Indeed. So when we used to do diligence on grids with some changes, but when we used to diligence on grids, essentially the client wanted to know, is there a grid connection offer in place? Can we see the bit of paper that says it's got grids? And you go, yep, it's got grids. Here's the offer. What's the date? We've got the date. Tick, move on. And in fact, it was never a particularly large part of the diligence because most people were relatively comfortable with the system. But yes, as you see, anyone who wants to buy a renewable generation development project right now, one of the key things to attributing value to that project is understanding when it is likely to get connected to the grid. And therefore, that means some analysis of right now where it might sit within connection reform and how certain is the grid date that is currently sitting in that grid connection document, and how likely is it that that may change. Obviously, the value that you might attribute to a project which is connecting next year versus one that's connecting in 2030 is quite different. So yes, it's increasingly important, and one of the first things now clients are asking us when we're looking at new projects.
So your jobs become much more difficult. Is that what you're saying?
Much more interesting.
More interesting. That's the word. And Neil, you were telling us about well, I suppose the various implications for the consenting system, both of the push for planning applications or Section 36 applications coming through to try and hit these relevant milestones, as coupled with at the same time the applications for the transmission infrastructure itself, and just the busyness, if you like, of the system. When we're thinking about the transmission infrastructure, I mean, these are all national developments at that level. Does that, am I naive to think that may give them an easier ride through the system?
It's not naive. If I'm applying for permission for a national development, I'm much happier if it's got national development status. The legal speak on that is that means you don't need to show a need for the development. The national development designation makes that implicit or sort of pre-decided, as it were. So that's a big step up. But I think the thing that puzzled everyone, and still does to some extent, that a national development follows the same consenting procedure as any other development. It doesn't get any time priority. It doesn't get an abbreviated consenting system. It just gives it, as I was saying, that extra leg up, because you don't need to show a need for the development that's already been established. So good to have, but it still leaves you with a lot of work to get the application through the system and get that consent.
That's a fair comment, and as we've seen from projects recently in the headlines, such as the Kendun to Tongland project, where the reporters had actually recommended against the project, albeit the ministers granted consent under Section 37 at the end of the day for the overhead line. Clearly, these are often controversial projects from the perspective of those in the local communities who feel they will be affected by them. It's probably also worth saying that not only are we having to think about those consents under the Electricity Act, but of course, in order for the transmission companies, etc., to be able to then deliver those projects, they need to secure the land rights at the same time. So they're also thinking about the way leave processes, and that's something else that anyone looking at the DPA portal will see a lot of at the moment, because there are numerous cases which will end up being referred to the DPA, which will be a high number for any project of that scale, in order to, where you're crossing numerous land interests. So a lot to keep the reporters busy. Okay, so just seeing if we have any further questions from the listeners at the moment. Now, I don't know if this is maybe a bit of a tricky one for us to finish up on. We've been focusing mostly on the onshore discussion today, but in terms of our discussion to date, is the same process going to have application to offshore projects, SJ?
Yes, so the connection reform process and the queue management process applies effectively technology agnostically, if that's a word, so that the milestones end up in everyone's grids connection agreement, and so offshore projects will be required to satisfy the same milestones as onshore projects. Similarly, offshore projects will be subjects of connection reform and the same process as everyone else. I think there's, I suppose, two key points there. One of which is that certainly for offshore projects in Scotland at the moment, their current connection dates are quite far away. So many of them beyond 2030. So as part of connection reform, I'm sure many of them will be hoping that they can bring their grid connection dates forward. And the other important thing for offshore wind is that is a key plank of the Clean Power 2030 mission. And so to the extent that they have a grid connection date already or are seeking to be advanced, the NESO needs them to deliver the Clean Power 2030 mission, and therefore they are likely to retain a place in the queue and potentially even be advanced because they are seen as things that are needed. It is obviously a key part of the UK government's plan is to have more offshore wind. So yes, while they are going to be treated the same as everyone else, they are seen as a priority project.
Okay, well, that makes sense. Neil, if I can perhaps just throw one at you before we wrap up for the day, and we have a question from Fraser James. Fraser's asking, what are the implications of the milestones and connection reform for preparing LDPs? Should authorities be collating this information from operators during plan preparation? Now, of course, we don't typically have land allocated for the purposes of renewables projects in LDPs, but do you see a relevance there in terms of, I suppose, thinking about infrastructure first and just these key themes? Should this be something that local authorities are interested in their early stages of plan preparation?
It's a great question, and it would be very easy just to say, well, we really need to wait for the Scottish Government to tell us whether or not that should happen. But that's a rubbish answer. So I'll keep going. MPF 4, policy 11 again, but it's the bit just before where it's what's expected of local development plans. And it says LDPs should seek to realise their area's full potential for electricity and heat from renewable, etc., by identifying a range of opportunities for energy development. And for me, the key words there are full potential, range of opportunities. So picking up on what you said, Karen, unlike, say, housing development, certainly up till now, it's not been a situation where LDPs are expected to allocate sites for electricity generation. And what I've just read out doesn't necessarily say you have to allocate sites. It's talking about identifying a range of opportunities. So it's a bit vaguer. And I think one of the important things for me is the LDPs now will have a 10-year life. SJ's been talking us through what sounds like a process of considerable change in the way that grid connection will be approached. I just wonder whether, like all big periods of change, there'll obviously be a bedding in period after it. But I would be slightly worried that that new system will not necessarily stay the same for the whole 10-year period of an LDP. So I would feel, if I was a planning authority, I wouldn't necessarily want to place too much weight on the grid connection timeline available, the grid connection timeline, the grid connection timeline information that would be available, because that may well change during the life of the LDP. So I think, yes, interesting to have a look, but I can see all sorts of difficulties of what a planning authority would do with that information, unless it was able to show some big absolutes, sort of high-low of the timelines, meaning almost nothing was going to happen within the LD period, or the timeline showing that lots was going to happen. I think once you get past that, if you try and refine it to any sort of level of detail, I think there's a big risk that the predictions would turn out to be incorrect during the lifetime of the plan. So worth a look, but handle with care, I think.
Can I just add one brief thing to that, please?
Sure.
Not on the specifics of the grid data, but just to be aware that as part of NESO's new role, they have introduced this concept of regional energy strategic plans, RESPs. There'll be a few of them across the whole of the UK, one for Scotland. And the point of that is to make sure that we're being much more joined up in terms of what energy infrastructure is required in local areas to meet particular strategic aims on growth. And so I can see that potentially having a bit more integration with things like local development plans, because local authorities will be part of that planning process. And I mean planning in the sense of strategically planning the thing out, not planning in the kind of planning permission sense. But I think there is more integration there.
Yeah, and that's got to be a good thing, because I've certainly heard complaints from house builders that they're struggling to deliver housing sites because they can't get engagement from, let's just call it, the energy providers, because I don't want to trespass in and get the terminology right. And ironically, someone suggested, and I think they were fairly serious, that the best way of getting energy sorted for your housing site was to co-locate it with a really big data center proposal, because that is so energy hungry. Someone would sort something out and you could just almost piggyback your housing onto that, which is a very interesting way of thinking. But it does illustrate, we've been focusing on connection to connect up generation assets. But the other end of the equation is the supply one that you mentioned, where, for instance, if it's housing or if it's, well, to take the example of data centers or energy intensive industry, to do proper strategic planning in an LDP, you do need to have a think about where that supply will be coming from. So it's great that there's that sort of regional focus coming through, because that will help the information to be available for the LDPs.
Great. Well, I think that is just about us for today then. I think that's been absolutely fascinating. As I said at the beginning, I feel I have already, was already learning a lot. So thanks very much, SJ and Neil. And if I can just give a plug for our next Planning Live session, which will be on the 19th of June. So you can stick that in your diaries just now. If you'd like to join us again in a month's time, further details of that will come out in due course. We'll tell you what we're going to be talking about. In the meantime, if you would like to contact us to have a chat about any of the issues that were being discussed today, please do that. We'd be delighted to hear from you. So just remains for me to say thanks again to Neil and SJ, and hope everybody has a pleasant evening.